Hi, I'm Paul Vicheski. I'm the director of Randall's School of Real Estate located in Omaha, Nebraska, and we're continuing with our video series regarding the Nebraska Landlord Tenant Law. Tonight's lesson is on the 3-day notice to pay or quit. Now, the 3-day notice to pay or quit is specifically used by the landlord or property management and given to the tenant for the tenant's non-payment of rent. This notice is the only notice that can legally be used for the non-payment of rent. No other part of the landlord-tenant relationship would we use a 3-day notice to pay or quit. Because we are discussing things that are in the legal realm, I do require you to read the disclaimer that's on your screen. And when you're done reading the disclaimer, then proceed with the rest of this video. The 3-day notice to pay or quit. One thing we have to understand is this is not a notice for the tenant to vacate. It is not a notice to the tenant to say to the tenant, pay the rent or the total amount that's due, or you have to move, or the landlord is going to change the lock. It's a required legal notice to the tenant that says you owe this amount of rent and applicable late fees, and if you don't pay it, then the landlord can terminate the lease and then proceed with the eviction. There's a lot of myths and misconceptions about this notice. It is not a notice to vacate. It gives a legal notice to the tenant to pay the entire amount that's due, or the landlord can terminate the lease agreement and proceed with the eviction. Very important part of this process. All right, before we move on, we really have to understand the 3-day notice part. In the statutes provide for a strict construction of the time frames. I did a previous video on what is proper notice, and I highly recommend that you go back and you watch that video before you continue with this video. It will help you understand the timeline part of this notice. However, I wanted to outline 2 proper timelines, or most common timelines that we see with lease agreements. So I have them listed up here. The first one is the rent is due on the 1st and the rent is late on the 5th. So many of the leases will have that the rent is due on the 1st period, and if you don't pay, then you're in breach. Some leases will have that the rent's due on the 1st, but it's not late until the 5th. We call that a grace period. In this case, I'm going to deal with the first part, which is the rent is due on the 1st. So in our scenario, the rent is due on the 1st, and he or she doesn't pay. So on the 2nd of the month, the landlord or property manager would then deliver the 3-day notice to pay or quit. This day is called the day of service. This day does not count as one of the 3 days of the notice period. Okay? This is a freebie for the tenant, if you will. So on the 3rd of the month is when the first day of the notice starts. So there is a 3-day period here called the 3-day notice period that covers the 3rd, the 4th, and the 5th day of the month. If the rent is $500 and there's a $50 late fee indicated in the lease agreement, then the total amount that's due to the landlord is $550. If the tenant were to bring the $550 to the landlord within one of these 3 days, during the 3-day notice period, the landlord must accept the full amount. However, if the tenant fails to pay, let's go back here, fails to pay the rent within that 3-day period, and it's the 6th of the month, and they still deliver to the landlord the full amount that's due, the landlord can say, no, I'm going to move on with the eviction, or they can accept the $550 and everything goes back to the way it was. So the important thing to remember here is that 3-day period. If the tenant does provide the full amount that's due as indicated in the 3-day notice, and we will be discussing or looking at a 3-day notice here in a minute, then the landlord must accept it. Now let's say that the tenant shows up and they only have $500 of the $550 that's owed. Maybe they brought the rent but not the late fee. The landlord then has 2 options. The landlord can accept the $500. If the landlord accepts the $500, which is $50 less than the full amount, then essentially what the landlord is doing is postponing any eviction until the following month. It doesn't mean that the $50 isn't still owed. It is. All right, but it just means that if it's not paid by the next month, then the landlord can evict for that $50, but they have to wait to the following month. Okay, it postpones. Basically, if the landlord accepts any amount of money, it postpones any evictions for that month. All right, so very important to understand that. The same rules would apply here or the process if there's a grace period built into the lease agreement. All right, a couple other things I want to talk about here. Delivery of the notice. Under the statute, allows two types of delivery. The first one is by hand delivery or mail. I'm not going to talk about either of those. Please refer to the proper notice video that I did previously to discuss those processes individually and why it's really, from a landlord point of view, never really a good idea to serve a notice via registered or certified mail. We did talk about accepting rents within that 3-day period and accepting partial rent payments. I do want to focus quickly on LLCs and S corporations. It is very common for landlords to purchase and own rental property as an LLC, not so much as a corporation, but an LLC, a limited liability company. It's very important whoever is authorized under the operating agreement of that LLC that they be the ones that sign the 3-day notice. Anybody can serve the 3-day notice. Anybody can drop the notice in the mail, but the right person has to sign it. So let's say that there's 3 people that own the LLC. There's the husband, the wife, and maybe a cousin. The husband, the wife, or the cousin are typically indicated in the operating agreement as the person that has the right to sign legal notices and those type of things on behalf of the entity. So those people, that person would need to be the one that signs it. The reason is from the landlord's perspective, if the tenant were to show up, they could actually use that as an affirmative defense to delay or postpone the eviction by saying that the person that is legally required to sign the notice, that has the legal authority to sign the notice, didn't. It's just what you're doing from the landlord's perspective is trying to eliminate any potential legal defenses or affirmative defenses the tenants may be able to raise should they show up in court. The last thing I want to talk about here is look at an actual 3-day notice. This is a Nebraska specific 3-day notice. What I want you to understand in the legal realm is anytime that words are capitalized and bolded, it is a point of emphasis. It means that they have greater importance than the regular text. So let's look at this. It says 3-day notice to pay and intention to terminate the lease agreement for non-payment of rent. We want this notice to be as non-ambiguous as possible. We want the tenant who didn't pay the rent to absolutely know what the intention of this notice is. It goes on to say, it goes on to say that this is a legal notice. Time is of the essence. Failure to comply with this legal notice may result in legal action against you. Consult with an attorney if you do not understand. One of the other things that we're trying to eliminate, another affirmative defense here, is for the tenant to show up in front of the judge and say, Your Honor, I really didn't realize how important this notice was. Had I known, I would have taken it to an attorney to get some advice. It kind of removes that affirmative defense that they may be able to raise. The other part that's really important with this notice is the itemizations of the amount due. Remember I said earlier in this notice that the landlord must indicate the full amount that's due in the notice, and the tenant must pay the full amount due within that 3-day period. So in our scenario, maybe the tenant owes for the month of January and the month of February. So what we would do in here is put in the monthly rent that's owed for each of those months. In this case, it's $500 per month. And then we would also list in here the late fee as indicated in the lease agreement. Okay, so we write that in there. So the total that's owed is $1,100. And we would also indicate it up here as well. All right, this is the total amount that's owed. So if the landlord forgot to put in the late fees, they are jeopardizing their ability to collect those or require those of the tenant or deduct those from the security deposit at a later date. So it's very important that the landlord put in the correct amount and total amount that's owed. And the last part, and then we'll be done with this notice, and that is the statute infers that the method of delivery be indicated in the notice. In this notice, hand delivery and mail delivery is indicated here. You would check here as a landlord which method you use. Maybe use both. That's okay too. And then we put the date of delivery and then by whom it was delivered or by whom dropped the notice into the mail. Very important that also be indicated in the notice as well. That pretty much does it for the 3-day notice to pay or quit. If you have any questions, please ask them in the comments section below. I do encourage you, any comments, good or bad, that you have or anything that you would like to see in future videos. With that being said, again, my name is Paul Vacheski. I am the director of Randall School of Real Estate. We are the largest provider of real estate education in the state of Nebraska. So if you need any real estate education help, check us out at www.randallschool.com. And we have a list of all of our classes and courses available and pricing and availability and everything else right here, randallschool.com. So until next time, in the next video, happy landlording.